Hello everyone, and welcome to this high-stakes revision session on tort law, specifically designed for the AS and A-level law 9084 syllabus. Today we are mastering a rule that has defined property rights for over 150 years, Rylands V Fletcher, 1868. As you know, Paper 4 requires not only a deep understanding of legal principles, but the ability to apply them to complex, real-world scenarios. We are going to tackle this topic the way a lawyer would, by diving straight into a scenario-based challenge. The challenge: strict liability. In the majority of tort law, think back to your studies on negligence. The burden is on the claimant to prove the defendant was at fault or acted carelessly. You look for a breach of duty. However, Rylands v Fletcher is a different beast altogether. It is a strict liability tort. This means that if certain conditions are met, a defendant can be held legally responsible for damage even if they took every possible precaution and hired the best experts. In this area of law, it's not about how hard they tried to be safe. It's about the fact that a thing they brought onto their land escaped and caused foreseeable harm to a neighbor. Why this matters? This rule was established during the Industrial Revolution to deal with the new risks of large-scale land use. For your exam, you need to understand how the courts balance the rights of a landowner to use their property with the rights of their neighbors to be safe from mischievous escapes. Ready to see how this plays out in practice? Now, let's take a look at our sample question. In this scenario, we have two distinct issues involving Newtown Recycling and their neighbor, Clarissa. We are looking at a dispute between Newtown Recycling, based on an industrial estate, and their neighbor, Clarissa, who runs an organic allotment. The scenario presents two distinct incidents. 1. The oil spill. During a severe storm, an oil tank overflows after its lid is blown off, damaging Clarissa's crops. 2. The tire fire. A lightning strike ignites a pile of tires, resulting in smoke and soot damage to Clarissa's greenhouse. Clarissa wants to know if she can bring a successful claim under the rule in Rylands v Fletcher. Before we advise her, we must first understand the origins of this rule. In our next slide, we will step back from this scenario to analyze the landmark 1868 case itself, exploring its facts, the court's reasoning, and the fundamental rationale that created this unique area of strict liability. To understand the rule, we first have to understand the drama that started it all. Let's look at the background and facts of the original 1868 case. 1. Background and context. Before this case reached the courts, the legal default was negligence. If something went wrong on your neighbor's land, you had to prove they were personally careless. Rylands v Fletcher changed the landscape forever by establishing strict liability. This meant the court was less interested in how careful the defendant was, and more interested in the fact that their project caused a disaster for someone else. 2. The facts. The parties: we have Rylands, the defendant who owned a mill, and Fletcher, the claimant, who ran a neighboring mine. The action: Rylands wanted a reservoir to power his mill. He did the right thing by hiring independent contractors, engineers who were supposed to be experts, to build it. The incident: while digging, the contractors found some old, disused mine shafts. They didn't realize these shafts actually connected to Fletcher's active mine next door, so they failed to seal them properly. The escape: as soon as the reservoir was filled, the sheer weight of the water caused it to burst through those old shafts. It traveled underground and completely flooded Fletcher's mine. The legal dispute here is the twist. Rylands himself hadn't been negligent. He wasn't the one digging, his contractors were. Under the laws of the time, he couldn't easily be sued for their mistake. However, the court decided that because Rylands brought a dangerous thing, a massive amount of water, onto his land for his own purposes, he was responsible for it at his peril. This set the stage for the four-part test we use today in your exams. Now we reach the technical core of the topic: the ratio decidendi and the specific legal framework you must master for your exam. 3. The ratio decidendi, the legal rule. The ratio is the central legal principle established by this case. It was famously articulated by Blackburn J. in the Court of Exchequer Chamber, and remains the gold standard for strict liability today. The rule states: the person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. In short, if you bring a potential hazard onto your property for your own benefit, you are responsible for it at your peril. If it gets out, you are liable for the consequences, regardless of your intentions or how careful you were to prevent the accident. 4. Key requirements of the rule. To succeed in a problem question and prove a Rylands V Fletcher claim, you must prove that the scenario meets 4 specific requirements. Think of these as the 4 pillars of your legal argument: accumulation, likely to do mischief, escape, non-natural use. Memorize these 4 headings now. We aren't going into the definitions just yet. We will break each one down individually later, so you know exactly how to apply them to messy exam facts. However, before we look at what these requirements mean in practice, we first need to understand the why. In the next slide, we will look at the rationale for these rules. Now we turn to the rationale, or the why, behind the decision. Understanding the judge's logic is key to scoring top marks in your 90/84 essays, as it allows you to evaluate the law rather than just stating it. 4. Why did the judges decide this way? The decision in Rylands v. Fletcher wasn't random. It was a deliberate choice to prioritize protection of property rights. The court used several key justifications. Risk allocation. The court felt that if a person chooses to engage in a non-natural or risky activity, such as storing massive amounts of water, they should bear the cost of any damage it causes to neighbors. It is unfair for an innocent neighbor to bear the loss of a risk they didn't create. Strict responsibility. The rationale is that certain activities are so inherently risky that simply taking care isn't enough. The law demands that the owner be 100% responsible for keeping that substance contained. Property interests. This reflects the 19th century legal focus on protecting a landowner's right to enjoy their property without interference from dangerous neighboring activities. By establishing this rationale, the judges created a safety net for property owners in an increasingly industrial world. Next, we will look at the applicable principles of the rule, starting with the rules on standing. Who exactly can sue or be sued under this tort? Now we get into the essential procedural question: who has the right to bring a claim? In legal terms, we call this locus standi, or legal standing. This is a frequent trap in exam scenarios, so pay close attention to the claimant's relationship with the land. 2. Key principles: who can sue? To have the legal standing to bring a claim under Rylands v. Fletcher, the claimant must meet a very specific property requirement: proprietary interest. The claimant must have a legal right to the land affected. This generally includes the owner, a tenant, or a person with exclusive possession. The authority: Hunter v. Canary Wharf, 1997. This is your go-to case for standing. It established that mere licensees, such as guests, family members, or employees, cannot sue, because this tort is specifically designed to protect property rights, not people. No personal injury. Following the decision in Transco v. Stockport, 2004, it is now settled law that a claimant cannot sue for personal injury under this tort. It is strictly for property damage and related economic loss. The legal issue in practice: whenever you see a name like Clarissa in a scenario, your first task is to determine if she possesses the necessary locus standi. Based on the rule in Hunter v. Canary Wharf, 1997, the court must determine if she holds a proprietary interest in the affected land to qualify as a valid claimant. Now that we know who can bring the fight, the next slide will look at the other side of the coin: who can be sued. Now that we've established who is entitled to bring a claim, we have to look at the other side of the courtroom: who can be sued. In Rylands v. Fletcher, liability is generally placed on the person who controls the source of the risk. Key principles: who can be sued. In your exam, identifying the correct defendant depends on one major factor: control. The occupier owner. Generally, the person who has control over the land where the substance was accumulated is the one held responsible. Non-delegable duty. This is a vital point for your essays. The defendant is held liable, even if the actual danger was created by an independent contractor they hired. You cannot pass the buck to a builder or engineer to escape strict liability. The authority: Rylands v. Fletcher, 1868. In the original case, Rylands didn't build the reservoir himself. Experts did. But his locus, or control over the land, made him legally responsible for what happened on it. The legal issue in practice. When analyzing a scenario involving a company like Newtown Recycling, your primary issue is whether they are strictly liable for property damage caused to a neighbor. The court must determine if their accumulation, perhaps of motor oil or used tires, constitutes a non-natural use of land. We also have to consider external factors: if an escape was triggered by a massive storm, Could the defendant rely on the defensive act of God? Now that we know the parties involved, the next slide will take us through the specific elements of this tort that you must prove to win a case. We now move into the deep dive of our 4 pillars, starting with the first mandatory requirement, accumulation. For any claim to even begin, you must prove the defendant actually brought something onto their property. 1. The requirement of accumulation. In legal terms, accumulation means the defendant must voluntarily bring the substance onto the land for their own purposes. This is a crucial distinction from things that are already there. The key test: the substance must not be naturally occurring on the land. If nature put it there, the defendant isn't responsible for it under this rule. Case law: Giles v. Walker, 1890. This is your primary authority for this element. In this case, the defendant was not held liable for thistles spreading to a neighbor's land because thistles grew there naturally. The contrast: unlike the natural thistles in Giles, the defendant in Rylands specifically chose to bring a massive volume of water onto his land where it hadn't been before. Revision note: if a substance like a pile of rocks or a natural pond is already present when the defendant purchases the land, it generally does not count as a legal accumulation. Applying the principle, when you are looking at your exam scenario, you need to ask, did the defendant bring something onto the land that wasn't naturally there? For instance, if we look at Newtown recycling, we have to determine if the damage was caused by the actual substance accumulated by them leaving their land. If the damage was caused by a secondary effect, like smoke, it might not qualify under the strict rules of Rylands v Fletcher. Once you've proven the substance was accumulated, you must then prove it was mischievous. We now move to our second pillar, likely to do mischief. This element focuses on the potential danger of the substance if it were to get out of control. Likely to do mischief. It is important to clarify that the substance itself doesn't have to be inherently lethal or radioactive. It simply has to be something that is likely to cause damage if it escapes. The key test: foreseeability of damage. While the escape itself doesn't have to be foreseeable, the type of damage must be. Case law: Hale v. Jennings Bros, 1938. In this case, a chairplane car at a fairground flew off its mountings. The court ruled that this was a substance likely to do mischief if it escaped its intended orbit. Application tip: for your revision, remember that even seemingly harmless things like water or gravel can do mischief if they are collected in large enough quantities. The legal issues in practice. When applying this to a scenario, such as a terrible storm causing an oil leak, you must ask, does the storm change the fact that the oil was likely to do mischief? The answer is no. The escape doesn't have to be foreseeable, only the type of damage if an escape occurs. Another common issue is the remoteness of the harm. For example, is soot damage to a greenhouse a foreseeable type of harm from a tire dump? If a fire was caused by an act of God, like lightning, a defendant like Newtown Recycling might argue that the specific mischief was too remote to be their responsibility. Next, we will look at the third requirement, the escape itself. We now move to our third essential pillar, the escape. This is perhaps the more straightforward element to identify, but it is often where many students lose easy marks by missing the technical distinction. 4. Escape. Strict liability under this rule is only triggered if the substance actually crosses the boundary of the land. The key test: there is no liability unless the substance leaves the land that the defendant occupies or controls, and moves to a place where they have no control. Case law: Reed v. Lyons, 1947. This is a critical case for your exam. An explosion occurred inside a munitions factory, injuring an inspector. The claim failed specifically because the dangerous substance, the shell, never left the defendant's property. No escape means no claim under Rylands v. Fletcher. Modern update: LMS v. Styrene, 2005. This case provided important clarification for fire-related scenarios. It established that if a fire is started by an accumulated flammable substance, and that fire escapes, it can count as a valid escape under the rule. The legal issues in practice. When you are analyzing your scenario facts, you must look at the physical movement. First, does the movement of the oil satisfy the test in Reed v. Lyons? Second, if the scenario mentions smoke, you must ask if that constitutes an escape of the accumulated substance, in this case, the tires themselves. Remember, if the mischief stays within the defendant's fence, you cannot use this tort. Finally, we will look at the fourth and final pillar, non-natural use of land. We've reached what is often the most critical element for evaluation in your 9084 essays, non-natural use. This is where the law moves away from simple facts and into the territory of judicial interpretation, focusing on whether the land use was extraordinary and unusual. 5. Non-natural use. The focus here is not on whether the substance is organic versus man-made. Instead, the court looks at the context of the activity in relation to its time and place. The key test: it is not about nature in a biological sense, like trees versus buildings. Rather, the court asks, does this use provide a general benefit to the community, or does it create an increased risk? Case law, Rylands V Lothian, 1913. In this instance, leaving a tap running was considered a natural use because a domestic water supply is a normal, everyday necessity for modern living. The modern standard, Transco plc v Stockport MBC 2004, the House of Lords refined this further, emphasizing that non-natural refers to an activity that creates an exceptionally high risk of danger. For example, while a normal water pipe in a block of flats is a natural use, a massive industrial reservoir remains non-natural. Evaluation in practice. When writing your answer, remember that what was non-natural in 1868 might be considered perfectly normal today. You must always argue whether the defendant's specific use of the land, like the massive tire dump at Newtown Recycling, exceeded the ordinary use of land for that specific area. Now that we've covered all 4 pillars, we need to look at how a defendant can fight back. Next, we will cover the specific defenses available under this tort. Even with strict liability, a defendant is not always automatically liable. There are several general available defenses recognized by law that can be used to defeat a claim. 6. Available defenses. When analyzing a scenario, you must check if the defendant can rely on one of these 5 categories. Act of God, vis major. This applies to an escape caused by natural forces so unforeseen and extraordinary that no human foresight could have guarded against it. Act of a stranger. The defendant may not be liable if the escape was caused by the deliberate, unforeseeable act of a third party over whom they had no control. Statutory authority. If a specific statute expressly authorizes the accumulation of the dangerous thing, the defendant is usually only liable if it can be proven they were negligent. Consent of the claimant. This defense is used if the claimant expressly or impliedly consented to the presence of the dangerous substance for their own benefit. Default fault of the claimant. A claim will fail if the escape was caused entirely by the claimant's own actions. Evaluation tip. In your exam, don't just list these. Look at the facts. If there was a storm, was it a normal storm or a once-in-a-century event? If a third party was involved, did the defendant have any way to stop them? Your ability to apply these defenses to the facts is what separates a passing grade from an A. Now that we have the full legal framework, from the pillars to the defenses, we are ready for the most important part, application. In the next slide, we will apply everything we've learned to a practical exam-style scenario. We have arrived at the application stage. This is where you demonstrate to the examiner that you can take the abstract rules we've discussed and apply them to a specific scenario with legal precision. 1. Application. Locus, legal standing. In any scenario, your first task is to identify the correct parties. Let's look at the legal standing, or locus standi, of the potential claimants in our case study. Clarissa's standing. As the owner of her property, Clarissa possesses the necessary locus standi under the authority of Hunter v. Canary Wharf, 1997. She has a proprietary interest in the land, which gives her the legal right to bring a claim against Newtown Recycling for the damage to her crops and greenhouse. The daughter's standing. Now consider Clarissa's daughter. Even though her clothes were ruined while she was helping out, she would not have a right to sue under Rylands v Fletcher. Why? Following Hunter v Canary Wharf, she lacks a proprietary interest in the land. Her loss involves personal property, chattels, or personal injury, types of claims that the modern interpretation of the tort, established in Transco, specifically seeks to limit. Identifying the defendant. On the other side of the dispute, we have Newtown Recycling. Legal control. Because Newtown Recycling owns a unit and operates a recycling center, it has the legal locus, control, over the land. The decision maker. They are the party that made the active decision to bring and keep the oil and tires on the premises. Liability. Since they maintain control over the source of the risk, they are the proper defendants for this claim. Always start your exam answers by clearing this hurdle. If the claimant doesn't have the right to sue, the rest of the elements won't matter. With the parties identified, we move to the first substantive hurdle of the Rylands v Fletcher test, brought on land and accumulation. For the claim to proceed, we must prove the defendant actively collected the hazardous material rather than it being there naturally. 2. Brought on land, accumulation. In our case study, we have two distinct areas of potential liability to analyze: the oil and the vegetables. It is objectively clear that the motor oil was brought onto Newtown Recycling's land and accumulated there. This wasn't a natural occurrence. Storing and processing oil is one of the fundamental, deliberate functions of the site as a recycling center. The greenhouse and the smoke. Similarly, there is no doubt that Newtown Recycling brought the tires onto the land. The tires were accumulated in large quantities as part of the site's commercial operations. The legal significance. By showing that these materials were accumulated for the defendant's own purposes, we satisfy the first requirement of the ratio. The focus here is strictly on the deliberate act of gathering the substance. Now that we've established that the materials were brought onto the land, we must move to the next requirement. Were these substances likely to do mischief? Now we apply the third requirement, escape, to the specific events in our case study. This is where we must distinguish between what physically left the land and what did not. 3. Application, escape. We have to analyze the two different incidents separately to see if they meet the strict legal definition of an escape. The oil spill, foreseeable mischief. Motor oil is considered a mischievous substance because an escape onto soil is virtually certain to cause property damage, such as destroying crops. In this scenario, the oil physically crossed the boundary onto Clarissa's land and caused direct damage to her vegetables. Because the oil is a substance likely to cause harm if it escapes, this satisfies the requirement. Burning tires and smoke. While burning tires are likely to cause harm, we have a technical legal problem. It was the smoke that escaped, not the tires themselves. Based on the decision in Stannard v. Gore, it is unlikely that smoke from tires would be viewed differently than fire from tires. Newtown Recycling NR can argue that since they brought tires onto the land and not fire or smoke, and the tires themselves did not move onto Clarissa's land, the Rylands V Fletcher rule doesn't apply to the tire fire. Strategic legal advice. If the Rylands V Fletcher claim fails because the accumulated substance, the tires, didn't physically escape, Clarissa isn't out of options. A student should note that she might be better off suing in private nuisance for the soot damage instead. Next, we will look at the final element of our application, whether these activities constituted a non-natural use of land. We conclude our application with the final and often most debated pillar, non-natural use of land. This element is highly contextual, requiring us to look at the specific location and the level of risk involved. 4. Application, non-natural use of land. To determine if Newtown Recycling's NR activities meet this requirement, we must evaluate them through the lens of established case law. The argument for non-natural use, under the authority of Cambridge Water, storing oil in large quantities, and the inherent danger associated with its escape, is a classic example of a non-natural use of land. The ordinary use counter-argument. However, following the standard in Transco, NR could argue that since they are located on an industrial estate, keeping oil and tires might be considered a natural or ordinary use for that specific type of land. If the court accepts this, Clarissa's claim under Rylands v Fletcher fails entirely. Foreseeability of harm. If the use is viewed as non-natural, then damage to soil from an oil spill is a foreseeable form of harm, likely allowing Clarissa to claim for her ruined vegetables. The tire storage. Similarly, it is submitted that storing tires in a recycling center on an industrial estate would not be considered out of the ordinary for industrial land. However, if Clarissa can overcome this barrier, damage to her greenhouse would also be viewed as a foreseeable form of harm. Summary of the case. In your exam, emphasize that the success of Clarissa's claim hinges on the court's interpretation of non-natural. If the court views a recycling center's activities as ordinary for an industrial zone, the strict liability of Rylands v Fletcher will not apply. With the application complete, we have now covered the full life cycle of a Rylands v Fletcher claim. Are there any specific cases or elements you would like to review further? Even if all four pillars of the tort are satisfied, a defendant is not automatically liable. We must check if any specific legal defenses apply. In our scenario with Newtown Recycling, the most relevant defense is an act of God, or vis major, specifically regarding the terrible storm that caused the escape. The threshold for act of God. Under the authority of Nichols v Marsland, This defense only works if the escape was caused by a freak weather condition so extraordinary that no human foresight could have anticipated it. The reality check. The court in Greenock Corporation v. Caledonian set a very high bar for this. They ruled that even floods of extraordinary violence must be anticipated if they are within the realm of possibility for that specific climate. Applying it to NR, while Newtown Recycling might argue the storm was to blame, in the UK legal system, heavy rain and storms are generally considered foreseeable risks. Since this wasn't a once-in-a-thousand-years event, the defense will likely fail. Final analysis of a case study. When you are writing your exam response for 9084, your final analysis of these facts should look like this. Locus standi, Clarissa has the standing to sue for the oil damage to her crocs because she owns the land. Her daughter does not, as she lacks a proprietary interest. The defendant. Newtown Recycling is the proper defendant because they had control over the land and the source of the risk. The oil spill. This claim is likely to succeed. The oil was accumulated, it was mischievous, and it physically escaped. The act of God defense fails because the storm was not extraordinary enough. The tire fire. This claim will likely fail under the principle in Stannard v. Gore. Why? Because Newtown Recycling brought tires onto the land, not fire. Since the tires themselves did not physically escape onto Clarissa's land, the strict liability rule of Rylands V Fletcher doesn't apply here. That completes the full breakdown of the application and defenses. This final slide is the A-grade differentiator. In the 9084 A-level syllabus, the examiners love to see students who don't just stick to one tort, but recognize that a single set of facts can trigger multiple areas of law. Conclusion. Advice for the claimant. While Rylands v Fletcher is a powerful tool for strict liability, modern interpretation has made it a difficult hurdle to clear. For Clarissa to maximize her chances of compensation, she must consider alternative legal paths. The strict liability struggle. Clarissa's Rylands claim is vulnerable to the act of God defense. If the court decides the storm was an unforeseeable act of nature, Newtown Recycling NR could escape liability entirely under this tort. The path of negligence. A stronger route may be a claim in negligence. If Clarissa can prove that NR was careless, for example, by failing to secure the oil lids properly despite knowing a storm was coming, the strict requirements of Rylands, like non-natural use, no longer matter. The path of private nuisance. For the soot and smoke damage, private nuisance is the most appropriate remedy. Unlike Rylands, which focuses on an isolated escape, nuisance focuses on the unreasonable interference with Clarissa's use and enjoyment of her land. We conclude our analysis with the most important part of any exam answer, the practical advice. While we've spent this session dissecting Rylands v Fletcher, a top-tier student always has a backup plan, because the storm and lightning might be legally classified as an act of God. Clarissa's strict liability claim is on shaky ground. However, she shouldn't lose hope. If she can show that Newtown Recycling was simply careless, perhaps by leaving an oil lid loose or ignoring fire safety protocols, she could win a much simpler case in negligence. Furthermore, for that messy soot damage in her greenhouse, private nuisance is likely her strongest argument. It focuses on her right to enjoy her property without being covered in smoke, regardless of whether a substance physically escaped in the technical Rylands sense. When you tackle your 9084 exam, always end your problem questions by suggesting these alternative paths. It shows the examiner that you don't just see a list of rules, you see a legal toolkit for solving a client's problems. Thank you for watching and good luck in your revision.